Hopefully you can all hear me. I'm just going to move around a little bit if that's okay. So I'm a lecturer in law at Sheffield University, and I also work for the Society and Ethics Research Group at the Wellcome Genome Campus as a legal academic expert. And a lot of what I do in my day job is comment on the law, take a theoretical kind of perspective on the law. That's not really what I want to do today, but I will direct you to some pieces of work where I have made comments on the law. What I want to try to do today is to talk about this case, talk about its journey through the English court system, through the High Court, and then the appeal in the Court of Appeal. And I want to try and dispel some of the myths, some of perhaps the sensationalism, and pick out some of the nuances of the case that might help you to have a good idea of what the impact might actually be for you in practice if you are held to be under a duty to inform family members about genetic risks that you've learned because of a test on a patient. Okay, so this is the core question here. So when should genetic information be disclosed to a patient's unsuspecting relative? Now, I'm sure many of you in the room, this is not a new question for you. This is a question that has troubled genetics professionals for decades, I think. The way that the common law system works in the UK is that it always plays catch-up. Because it waits for a grievance to arise, it doesn't preempt professional problems, it reacts to them. So even though this has been in professional minds for a long time, there's been very little legal clarity about exactly when people might be under conflicting duties. And it wasn't until 2015 that this issue came to be considered by the court in the genetic context. So the case that I'm going to focus on today is the case of ABC and St George's. But I just wanted to flag up to you that the year after this was heard in the High Court, we'll focus a little bit on the facts of that case of ABC in a moment, there was another case of Smith and the University of Leicester in 2016. And one of the most interesting distinctions between these two cases is that in the ABC case, as we'll focus on in a moment, if the practitioners involved informed the family members, they would be doing so in breach of the patient's confidence because the patient didn't consent to that disclosure. However, in Smith and the University of Leicester, the patient was actually a child, but the patient's family was supportive of disclosure to relatives, which in that case was cousins. This was also a genetic condition. So there would have been no breach of confidence. But equally in that case, there was still held to be no duty to inform. So it's not only that the duty doesn't bite if there's a breach of confidence. So in that case, the court said, well, it still is not incumbent on professionals to seek out family members and warn them, even if it wouldn't be a breach of confidence. This was actually heard in the shadow of ABC. So because we have a system of precedent, clearly the High Court decision in ABC did have an impact on the way the question of duty of care was interpreted in Smith and Leicester. Okay, so back to ABC and St George's. So I'm aware that many of you may be very aware of the facts of this case. So I'm going to portray them as they were portrayed in the court. So what happened in this case was a man in 2007 shot and killed his wife, and he was convicted of manslaughter on grounds of diminished responsibility. And he was then sentenced to a hospital order. And as part of the treatment under that hospital order, he was having family therapy with his two daughters. And I think part of that therapy was dealing with things like perhaps what would happen when he was released back into the community, given that he had killed their mother. And they were having this family therapy with, I think, a neurologist, a psychiatrist, and a social worker. The father, the man in 2009 was found to be suffering from Huntington's disease. And at this time, one of his daughters was pregnant and was still undergoing the family therapy. She gave birth to a child in April 2010. And there had been a question when she was pregnant, when they found out the father's diagnosis of Huntington's disease, whether or not this should be disclosed to his daughter. And in the notes, he refused to let this information be disclosed to his daughter for a number of reasons. And in the notes, there was some question on behalf of the professionals as to the wisdom of this decision. Nevertheless, they maintained his confidence and didn't inform his daughter, who then went on to give birth to her child in 2010. And then I believe that sometime after that, one of the other doctors who was looking after the father let the diagnosis slip to the daughter, and then she has subsequently been found to possess the gene for Huntington's. And the child hasn't been tested because it's contrary to professional practice to test in childhood, as I'm sure you all know. So this is the facts of the case. And then the daughter has alleged that the failure to tell her about her father's condition is actionable negligence. She also brought a claim under Article 8 of the Human Rights Act, which argues that there's an interference with her right to private and family life. This hasn't really been dealt with either in the High Court or the Court of Appeals. No focus really on the human rights position here. Perhaps because there's going to be a significant conflict with the father's Article 8 rights, his right to a private and family life. So very much the focus was on the action in negligence. The gist of the action in negligence, I don't want to go too much into the legal position, is that you have to show harm. If you can't show harm, there's no such thing as negligence in the air. I can be as negligent as I like. If I don't harm you, you have no claim against me. And the law takes a very traditional view of harm, and it looks at it as something very physical, normally. You know, it likes broken bones and those kind of things. It's very reluctant to recognise harms such as psychiatric harm or economic loss. So one of the difficulties for the daughter here, that her harm arose from the fact that she was unable to elect to have a termination, which she argued that she would have done had she have known of her Huntington's genetic status prior to giving birth. She argued that she would have opted for a termination. This is really quite difficult legally as harm. There have been some cases, and they focus on this issue of wrongful birth, where people have successfully argued that they should be able to claim compensation for the costs of raising a child that they would have elected not to have. So it's a very, very complicated case, this, and you can appreciate that the facts are very, very kind of unusual and specific. But this is one of the ways that the law develops. It develops in relation to specific factual cases, and then often what happens is the law gets tested again with a different set of facts, and then boundaries are drawn that way, which sometimes doesn't help professionals because it means you're constantly subject to this incremental developing of the law. So one of the problems with this, with the failure to inform her being actionable negligence, her argument conflicts with the well-recognised professional duty to maintain confidence. And this has been a historical duty that professionals are well aware that they're under. Now, the duty to maintain confidence is not absolute. People don't own their information, and they don't have absolute control over it. You can't always decide what's going to happen to your health information. There are reasons that confidentiality can be set aside. And one of those reasons is if it's in the public interest. Now, there's no clear definition of what public interest means. We do have cases where information about violent criminals has been passed on to prevent them being released from prison, or, and these kind of issues. And where there's a big violent threat, the courts have held that it might be in the public interest to share that information in breach of confidence. However, the High Court in ABC and St George's did actually say this wasn't a situation where the public interest outweighed the, this wasn't a case where the personal interest here could be considered a public interest, which might justify a breach of confidence. So this makes it all really quite confusing, because we do know that professionals can have a discretion to breach confidence, but that very much puts a lot of emphasis on the professional. Okay, when do they use that discretion? There's no duty, but using discretion can be quite difficult, particularly if you don't know what the legal grounds for breaching confidence are. You know yourself to be under a legal duty of confidence. Sometimes there may be a discretion to breach that, but what is the legal ground? And that makes for a very uncertain situation. And we don't have a case that's reached the courts where a person is arguing that a genetics professional breached their confidence. Clearly in ABC and St George's, that wasn't the argument. They hadn't breached his confidence, they maintained it. So we don't have any clarity about when a disclosure might be a breach of confidence. This case is all about when might there be a duty to warn. So, back to the crux of the case. Were the doctors negligent when they failed to inform the pregnant daughter about her father's Huntington's status? Okay, so the way that the courts approached this, even though this case dealt with individuals, the courts very much approached this case as a matter of policy. They saw this as a bigger picture. Okay, if we determine that there is a duty to inform, this is going to have a huge impact on potentially the provision of healthcare as a whole. So they approached this as a matter of policy, not a matter of individuals, and asked this question: did the public interest in disclosure outweigh the public interest in preserving confidence? And in the High Court, they were very, very clear that it didn't. This case was actually an application to strike out, which means they're testing the waters. They're saying, okay, well, we've got this conundrum. Let's test it before we gather all the facts. It makes the lawyers cheaper, okay, because they don't need to gather all the factual history. And they test it. They say, okay, these are the facts that we've got. Is there merit in this case? And the courts can strike it out as saying, I'm sorry, there's just no merit in this case, so we're not going to go to a full hearing on the facts. This makes it all a little bit more complicated. So in the High Court, the judge, Nicol J., struck the case out, okay, as having not sufficient merit for a full hearing on the facts. And the reasons why, he gave 9 policy reasons. And he talked very specifically about doctors. So I've written doctors here. That's not a mistake. But in the paper that I've referenced on there that I've written, I actually do critique that, because he talks about doctors. He doesn't mention genetic counsellors or geneticists. And it may be that actually thinking about just doctors as a profession generally could have quite a different perspective than genetic counsellors might about how you might deal with patients, how you might deal with families as patients. So he talked about the impact on the doctor-patient relationship, and he felt that if there were conflicting duties to inform family members and to maintain confidence, this would be detrimental to the trust between doctors and patients. Added to that, he felt that there'd be no way of knowing when people didn't want to be informed, and that this might actually expose doctors to additional liability that could interfere with their practice. Cumulatively, the feeling was that this would be overly burdensome on doctors and it wouldn't be good public policy. Like I say, I don't necessarily want to critique the law here, but I did write quite a sustained critique of this, which is published in Medical Law International, which you can read. And this paper that I wrote actually went in the bundle to the Court of Appeal. So it was considered in evidence to the Court of Appeal. So it may be just worth having a look at if you're interested in a kind of critique of the reasoning of the High Court. And then in May this year, the Court of Appeal heard an appeal against the strikeout application. So again, what the Court of Appeal are deciding is not whether or not there's a duty of care, but whether there seems to be sufficient merit in the claimant's argument that the case ought to be considered for a full trial on the facts. And only at a full trial on the facts would they decide whether or not there's a duty of care. Now, quite surprisingly here, the Court of Appeal felt that this was the time to quash the High Court strikeout application and said, actually, there's an arguable duty of care here. Now, I want to kind of very much focus here on what I think will be important for you to take from the Court of Appeal saying this. So they're saying that they are making things quite uncertain here. They're saying it's arguable that professionals are under a duty to inform family members in certain circumstances. The Court of Appeal puts significant evidence here on the professional guidance. So the guidance written by the Royal College of Physicians, Royal College of the joint guidance by the Royal College of Physicians, Royal College of Pathologists and BSHG. and GMC guidance that, that suggests that there are situations where patient confidentiality shouldn't be absolute, and there are situations where genetics professionals may want to inform family members of a patient's condition, even if that would breach the patient's confidence. Now, one of the things that's key here is that a duty would only bite where the professional balancing exercise concluded in favour of disclosure. So this wouldn't be a case of there being a duty to inform whenever you think a relative would want to know. It would be a case of, in any situation whereby you have a patient who doesn't want to inform family members, that the professionals would consider that, and they would either come down in favour of a disclosure as a matter of professional ethics, or they would come down in favour of maintaining confidence. And only in those cases where the professional balancing exercise concludes in favour of disclosure would there be a legal duty. Okay, so in those cases, what the courts effectively said is, well, where the professional balancing exercise concludes in favour of disclosure, it's not clear why the law is incentivising confidence, maintaining confidence. And I think that some of the empirical literature does suggest that there may be situations where professionals feel they ought to breach confidence, but they don't because they know themselves to be under a legal duty to maintain confidence. So it's kind of incentivizing this maintaining confidence, even where that seems to be contrary to what professional ethics is suggesting. So it's only in those very narrow situations where the professional exercise concludes in favour of disclosure. So this retains professional control. It's not that the family members have control and wherever they want to know, you should inform them. It's not that the law is telling you when you should inform. It's that you conduct your normal professional exercise, and then you would be protected if the duty is established. You would be protected because you would be able to say, well, the professional exercise concluded in favour of disclosure. And this is how the law works generally in relation to negligence. The way that you determine the standard is you always ask a reasonable professional opinion. And if you can find other professionals to support what you did, then you will not be held to have been negligent. So actually it will be extremely difficult, I think, to find a professional to have been negligent in these circumstances. In the ABC case, of course, they had recorded in the notes the wisdom of withholding the information from the daughter. So it does seem like these kind of circumstances may be the ones where it would be ultimately then for the professionals to say, okay, this isn't wise, the professional opinion is to inform, and we know that we are protected because we're under a duty. And once there are those conflicting duties, in that circumstance, you have a basis effectively for your breach of confidence that we don't have currently. The Court of Appeal was very keen to also limit this to the clinical genetic context that they were considering it in. This will be extremely fact-specific, and they particularly wanted to exclude other areas such as infectious disease, I think, violent threats from this potential arguable duty. And Lord Irwin said in that case that this duty would only, it's arguable that it's a duty where the relative should become a patient. And I think that's quite illuminating, really. They're not talking about genetic conditions where there's nothing that you can do. Now, clearly, Huntington's is an interesting example because the crux of the case there was that she was pregnant, okay, and that she could opt for a termination. But this would only be a duty to inform people where they should become a patient. And this relates to the fact that you have to show harm. Okay, so if there's nothing you can do about the genetic condition, then you can't have a legal claim just because somebody didn't tell you information that you wanted to know. You have to show that you suffered harm, which means that there would have been an opportunity to access healthcare that you therefore couldn't access, and you were harmed because of that. Okay, so what next for ABC and St George's? Well, currently, the case has been remitted for trial. Okay, now that means that it goes back to the High Court for a full trial on the facts, so there'd be much more fact gathering, and it would be a full consideration of all the facts. Now, as far as I'm aware, currently the lawyers for the claimant are trying to negotiate an out-of-court settlement. This is, I don't know where the situation is with that, and this will be extremely commercially sensitive information, I guess, because this will be negotiations between the trust and the lawyers for the claimant. So this leaves the situation extremely uncertain. If it goes back to trial and it's decided that there's no duty of care to inform, then we're back to the same situation where it's clear that the law incentivizes maintaining confidence. If the courts decide that actually there is a duty to inform in these circumstances, there will still be significant uncertainty, because what will follow that is when the law develops based on a system of incremental precedent, there will be several other cases that seek to define the boundaries, if you like, of that duty. So people in different circumstances will then bring claims that they are owed a duty of care, duty to inform. And those kind of boundaries will be set. So the law doesn't really, it's not just that there's a duty and then it all becomes clear. If this is settled out of court, then we really are in a situation of uncertainty, because what we've got at the moment is a declaration by the courts that it's arguable that there's a duty of care. And actually, the whole system of negligence back in 1935 developed on the basis of a strikeout application. So the reason we have a law of negligence developed based on strikeout. So it could be that this does develop now. What happens is that the practitioners assume themselves to be under a duty and start to act as if they are. But hopefully in that very narrow way that I said, only when it follows a professional, ethical opinion that informing the relatives is the right thing to do. So it's likely to take a significant amount of time until we get a clear picture of what exactly is going to be the impact of this decision. And one of the things that I'm doing at the moment is there's a paper that will come out of the Society and Ethics research group in the next, probably towards the end of this year, is rethinking the value that the law places on confidentiality in the context of clinical genetics, focusing very much on actually what are people's reasonable expectations, and when should people have a reasonable expectation that their privacy will be maintained. And it may be that in the context of genetic medicine, the boundaries of that can be kind of pushed, and that we can generally have this idea that sharing information in families is something that we should expect. Obviously, that doesn't mean that information should be shared outside of families. But again, that's much more of a kind of opinion and comment on the law, that rather than giving you an idea of exactly what the law is. So hopefully I've perhaps allayed some fears about that case and let you see that it's not this kind of whole wide sweeping duty that means you just have to inform people whenever you think that they want to know, but actually that the profession remains in control, and the law will only impose a duty where that seems to track the professional norms. Thank you.
Is there up there in the middle at the back? Oh, hang on. So Serena, and then there's Christine.
Thank you very much. Selina Goodman from Plymouth in the UK. Fascinating talk. I'd like your comments really relating to the issue of consent. So there's some argument that we could change the way we consent patients when we do testing or make a diagnosis that makes the consent relating to a familial diagnosis as opposed to an individual diagnosis. And I understand, so really a comment on that, please, but also I'm aware that the law has changed in France within the last couple of years, and I might be corrected by French colleagues here, but my understanding is that there is now an obligation placed on people who have genetic tests to inform their relatives of the diagnosis, and that has actually led to a change in the way the consent process has been carried out, at least in, I think, one Parisian hospital and possibly others. So could you just comment on how consent might affect this issue?
Yeah, so one of the ways to avoid a breach of confidence is to gain consent, and actually that's probably the best way. That's the way that maintains the most. There are other ways of actually setting aside the duty of confidence, but I think that consent is the paradigmatic example. I mean, historically, we've always had this worry about tying consent to perhaps disclosure up with tying it together with consent to a test or consent to a treatment. But I think that perhaps in this circumstance, we're moving towards a situation where, particularly if people are held to be under a duty, it becomes so difficult in situations where a patient does refuse to pass that information on, that it may be good practice to explain at the outset. And I think perhaps that would start that dialogue early on, and it would then, as long as it didn't put people off having the test, it would make those kind of non-disclosure scenarios much less common. I mean, I think perhaps they're not that common anyway, which sometimes makes it harder for the people that aren't informed, because generally from the literature it seems to be that there is a culture of sharing in families, which perhaps adds to the grievance when somebody is not given information. Does that kind of address the
French situation?
Yeah.
Does that influence? I'm just wondering if you could address the French situation with our colleagues in France and the coffee, and because we've probably got time for one more question, I want to get to the other person. Is that all right? Sorry, Serena, to close that down a bit.
Thank you. Chris Barlow-Stewart from Sydney, Australia. In 2006, there was an amendment to the Privacy Act made in Australia to allow disclosure to genetic relatives. And it took another 3 years for us to write the guidance for professionals. However, there was no duty to warn. Professionals, and they specifically talk about clinical geneticists or medical practitioners who can do this, if the circumstances allow it, but there is no duty, and I think that's a very important point. But the issue that I'd like you to comment on is that it applies to a person, to a genetic relative, not to a fetus. So in this case, because she was pregnant, would not be the reason that it could be disclosed. It would be the risk to her health. And I'd just like you to comment on that particular difference.
Yeah, I think it's a similar situation here, in that the unborn child has no rights until it's born. The fetus has no rights. Clearly, we allow legal abortion. So in this case, there can be no claim on behalf of the child. So if the child has the Huntington's gene, it can't claim that it shouldn't have been born. We don't allow that. Children have tried to bring claims for wrongful life, and they have been struck out as having no merit. Here, the claim is very much on behalf of the daughter of the father, who was pregnant at the time. Now, her harm is the failure to have the opportunity to choose a termination, which is problematic, okay? I mean, if this was different, if this was perhaps a gene for bowel cancer or something, and she'd missed screening opportunities and now had cancer, that in terms of the harm, that would make it more straightforward, because the law recognises that clearly as harm. It doesn't recognise you having a child as harmful to you, particularly if that child is healthy, because there have been many cases of failed sterilisation, completely outside the genetic context, where doctors clip a ligament rather than a fallopian tube, or they don't properly do a vasectomy. But where the mother elects not to have a child because of a disability on her behalf, the law has recognised that she may be entitled to some limited compensation. So because she has the Huntington's gene, the courts might say, well, okay, we will give you we will award you the compensation that's associated with the fact that you are going to be a parent bringing up a child with this condition. So it's nothing to do with the child. The child hasn't suffered any harm as far as the law is considered.
Thank you. As always, we've run out of time. We've got coffee, we've got lunch, etc. So thank you so much. Thank you, Vicky.